right, we're getting things started. Awesome. Hello and welcome to Judicial Wisdom in Action, a panel discussion on the journey from administrative patent judge to optimized advocate, hosted by Virtual Patent Gateway and moderated by Aziz. Virtual Patent Gateway founder Ashley Chung has a passion for supporting PTAB practitioners around the world and is committed to developing a growth mindset within VPG. We'd like to thank today's program sponsors, Gemini, Greenberg, Traurig, Fish and Richardson, Perkins Coie, Wilson Sonsini, and Womble Dickinson. Our moderator, Azie, is a patent agent and IP analyst at Womble Dickinson in the Houston, Texas office. She specializes in patent drafting and prosecution across various fields, including energy, electrical systems, software, wireless communications, and medical devices. We'd love for you to introduce yourself in the chat and tell us where you're joining us from. And with that, I'll hand things over to Azie.
Thank you, Caitlin. I would like to welcome everyone in our discussion on navigating the shift from the bench to the private sector. So our topic today, as Caitlin says, is the judicial wisdom in action, the journey from administrative patent judge, APJ, to optimized advocate. The discussion will explore into the journey of former APJs transitioning into roles as optimized advocates, and the discussion showcases the unique perspective and expertise these individuals bring to the legal industry. The discussion highlights how their prior experiences as APJs adjudicating complex patent disputes provides invaluable insights into litigation strategies, patent prosecution, and advocacy. The panelists today will share their real-world examples of how their judicial wisdom positively impacts their current roles and emphasize the importance of a balanced approach to intellectual property disputes, especially before the Patent Trial and Appeal Board, PTAB, at the United States Patent Trademark Office, USPTO. Furthermore, the panel emphasizes the value of collaborations between APJs-turned-advocates and the USPTO, fostering a more efficient and effective patent ecosystem. Finally, the discussion underscores the dynamic evolution of legal professionals and the role of judicial wisdom in shaping a more optimized and fair IP landscape. So let me share with you a bit about the format of this discussion today. We will start with 3 Slido questions. Then I am going to introduce the wonderful panelists here today. And after the panel introduction, we will hear the panelists sharing their experience. And in this discussion, we will have four subsections. And each sections, we will have a lead panelist. And the remaining 3 panelists will take turn to share their experience and thoughts. So section 1, it will be a career pivot. And section 2 is PTAB Insights and Judicial Wisdom. Section 3, collaboration between current and former world. Section 4 will be ethics. After we finish all these 4 sections, we will open the floor to the audience for question and answer you may have. And let me turn to Caitlin for Slido questions.
All right, everyone. So here is our Slido quiz. You should see it up on the screen. To join that quiz, you're going to use your mobile device to scan the QR code, or if you go to slido.com on your computer and type in that code number that you see there on the left-hand side of the screen, that should take you into the quiz as well. I will give just a second for people to join. Turn on some music while we wait. Why not? Oh, we got Trenton in. Trenton's going to take the quiz. Nicole and Abigail. Awesome. Jen's in. Ashley on board. We'll give it just another second, and then we'll move into the first question. All right. Here is our first question for everybody. Can someone without a USPTO registration number appear as counsel on a PTAB proceeding? We got 3 answers. Yes, no, and it depends, which I guess is maybe. Oh, we got 3 answers in. Let's see if we get a few more. I would ask you guys if you have guesses, but I feel like maybe you know the answer to this question, so we'll hold off for now. More answers in. All right, that's almost everyone. Oh, 86% said it depends. Got a couple people who said yes. And the answer is, it depends. Y'all know your stuff. All right. Next, go for it. All right, next question. How many days after notice of filing date is accorded before a patent owner preliminary response is due? Don't shout it out if you know the answer. Just put it in your Slido poll. Oh, we got 9 people on now. Let's see. Let's see how many more answers we can get in. Apparently, we're all on the same page. Let's see.
It's the right group, Caitlin.
It is. They know their stuff, man. Give a couple more people. Although I feel like at this point, everybody's like, well, if that's what everybody else thinks. Let's see. Oh, yeah. 3 months. Totally on it. All right. One more question for our live quiz. What are some career tracks APJs have within the USPTO? So we've got become an LAPJ. What does the L stand for?
Lead.
Lead. There we go. Become a lead APJ. Become a vice chief judge. Become a solicitor, or all of the above. Got 6 answers in. Oh, 7 answers in. Let's see. Let's see what people think. Oh my gosh. Everybody has the same answer. I feel like everybody just knows. Nobody's guessing. Although maybe for that first slide. 100%. I feel like we aced that quiz, you guys.
Absolutely.
Alrighty. That is all from me for now. Back to you, Azie.
Thank you, Caitlin. I don't know how many of you have the opportunity to meet APJs or former APJs in person. I certainly have not met one in person. So I have to do a little bit of research. Some backgrounds about APJs. APJs come from various backgrounds, but all have significant experiences in patent law, and candidates with 10 to 15 years of litigating and or prosecuting patents. And today we have 4 incredible panelists who are former APJs. And the first one is Jessica Kaiser. Judge Kaiser is a partner at Perkins Coie based in Denver. Fun fact about her, Judge Kaiser is an endurance athlete. So she completed her Ironman in 2018 in Boulder, Colorado, where she did a 2.4 miles swim, 112 miles cycling, and 26.2 miles running, a full marathon. And the participants had to finish within 17 hours. And apart from being endurance athlete, Judge Kaiser enjoys traveling, music, and going to comedy shows. That's very impressive. Any tips to those who are interested to do the Ironman?
I mean, I have a friend who says that Ironman is stupid and nobody should do it. But it was, a very good experience for me. And if you can devote the time, it makes you feel very good about yourself.
Awesome. And the second panelist, we have Trenton Ward. Judge Ward is a shareholder at Greenberg Traurig. Judge Ward is the father of 2 daughters, and one of his daughters is graduating from high school this year, and she's going to study risk management at the University of Georgia. According to Judge Ward, the daughter watched him long enough to know what she does not want to go into. So what's your favorite thing for you to be a father of 2 daughters, Judge Ward?
Thanks, Azie. And yeah, it's great to join in this discussion this afternoon. It's always nice to have a chance to talk to former colleagues, especially some of my favorite former colleagues. And I am a blessed dad of 2 daughters. And I'll tell you, I think this is true for all parents, but one of the greatest things as a parent is to watch your child. It doesn't really matter what they're doing, if they're performing in a musical or they're playing a sport or singing, etc., which I'm, blessed that my daughters do all those kind of things. So I think the greatest things is just literally sitting there and spectating and watching them show their talents.
To all parents, take note. And the third panelist, we have Lora Green. Judge Green is a partner at Gemini Law, LLP. And a fun fact about Judge Green, she and her husband are avid wine collectors. To date, they have over 2,000 bottles. So now we know where they spend their money. So Judge Green, do you have any specific favorite region?
We're equal opportunity wine drinkers. I feel like I should be more like Jessica and do the endurance sports, but instead my husband would like to travel to different places and go to different wineries. It's a lot of fun.
Very nice. And last but not least, we have Richard Torczon. So Judge Torczon is a senior counsel at Wilson, Sonsini, Goodrich, and Rosati. And the fun fact about Judge Torczon, his first job in patent law is outside of the USA. He started his patent career at Adachi International Patent Law in Nagoya, Japan. And Judge Torczon learned Japanese language and lived in Japan for 1 year. So Judge Torczon, why Japan at the time?
I have to start by pointing out that I have 3 adult children and none of them are anywhere close to patent law. So I get where your daughter's coming from, Trenton. Why Japan? Because it is a major patent country that is about as different and far away from any other of the major patent markets at the time. I'm an old guy, so we're talking many decades ago. And basically it was as weird as you could get and still be in sort of a big league patent market.
Excellent. Okay, now we are going to the first section, which is called Career Pivot, and which is going to be led by Judge Kaiser. So Judge Kaiser, you have an impressive career journey with big brand names such as ExxonMobil, Dow Chemicals, Kirkland & Ellis, and now with Perkins Coie. In your legal career, you were in the private practice before you went into the public service. So with that in mind, my question to you is, what considerations that led you to leave the bench and embrace a role within a private law firm?
Yeah, thanks, Azie, and it's wonderful to be here. And I'll say to Lora, I think she probably has it more right than me, so I should probably be drinking more wine. But anyway, so I guess as an initial point, and I think my co-panelists may agree with this, they may not, but other than being a law clerk for federal judges, which I was very fortunate to get to do both at the district court and federal circuit level, other than that, being a judge at the PTAB was my favorite legal job that I've ever had. And so that, of course, begs the question of why would you then go do something else? You had this wonderful job, you loved it. And as you mentioned, I started my legal career being an advocate. So I was at a different large law firm after I graduated from law school. And I always really enjoyed being an advocate, figuring out how to solve problems, how to craft arguments, and to advocate for clients. And when I went to the board, it was very much sort of a mid-career move for me. And I thought I would always go back at some point to being an advocate. And I went back into private practice about 2 years ago. And the timing for me was right in terms of how it matched up with the age of my kids. Like other people on this call, I also have 2 kids. Mine are one teenager and one tween now. And so that felt right. The amount of experience that I had gotten from the board and what I had learned felt like the right time. And so for me, it was something that I intended as part of my career trajectory, and the timing was good.
Hey, Jessica, I'll give you my way that I try and succinctly describe it. I say this often, but I don't think I've ever had a chance to test it against former colleagues. But Azie, one way that I describe the difference between being an advocate and being an adjudicator is that as an advocate, the job is to deliver the result that the client comes to you with, right? Like, you know the answer when you start. The client says, I want this patent to be invalid, or I want it to be valid, or I want it to be infringed or not infringed. So you know the destination, right? You know the desired outcome, and as an advocate, you're attempting to achieve that desired outcome. Very different activity as an adjudicator. As an adjudicator, you're trying to determine the correct result, which really accesses a different part of the brain, is what I found. So it's a very different activity. I don't know if others feel the same way.
Lora, I think you are muted.
Oh, I was going to say, I agree with Trenton. There are people who have come to the board and have not liked it because they did not like being the decision maker. They like being an advocate because they had the decision before them. As the judge, you really do have to step back, and your job is really making decisions. And then once you make that decision, how to justify it in a way that you can bring to the federal circuit. So it really is very different than being an advocate, but it does teach you how to be able to take that step back and think about a problem so that you're thinking about both sides of the problem. So it does make you a better advocate to be able to take that step back and not drink your own Kool-Aid, so to speak, and to be able to think about the strengths and the weaknesses of your adversary's position.
And how about you, Judge Torczon?
But I think it also goes the other direction too, though. It's valuable to come to judging having been an advocate, because it reminds you that what you're doing is real. It has consequences. And sometimes it helps you understand what otherwise might be inexplicable behavior. So it does work both ways. But yes, absolutely. Just this morning, I was talking to a colleague who was saying that, it must be easier to be a judge. And I'm thinking, no, it's actually a lot harder to make the decision when it's you. The one thing that makes it easier is, of course, there's so many checks in the system. The federal circuit's always happy to tell you when you got it wrong. So you have that comfort.
But of course, that almost never happened for Judge Torczon. So
I think I was there 20 years, and I think it happened 3 times. So that's a decent average, but not a perfect one.
Incredibly low.
Well, I think it's good to know that if you don't like it, you can always go back to where you were before. So moving to the second question, we are still within the same section, which is career pivot. Anybody can take up on these questions. How do you navigate the transition from being a judge to an advocate? If there are any takeaways that you can share with the audience.
Yeah, so Trenton made a good point that about knowing the answer first when you're an advocate. So certainly sort of what your position, your ultimate thing that you're advocating for is when you're an advocate. But I still think the problem solving skills and the way that you, as Lora was saying, the way that you approach the problem by kind of looking at and honestly assessing the weak points and figuring out how to address them. So for me, I feel like the transition has been relatively seamless because it uses a lot of the same skills, and you're just looking at it from a different perspective.
Yeah, I was talking to a colleague just this morning, and he's got a case that's back on remand. And so basically you're in a situation where the panel already gave you a favorable answer and somebody says, do it over again. And so one of the things we talked about is how you basically write for the panel what you want to say, them to say, so that, you know, you're helping them do what you have some reason to believe they already have an inclination to do. And that's, you know, that's a useful way to think about a lot of this. One of the things that's very useful in having the experience of being a judge is, at least when I was at an oral argument, the way I looked at it was as a working meeting to help me write a decision. So, you know, there were questions I needed to have answered, and I really wanted the opportunity to have the parties help me answer that. And so on the one hand, it's really easy. You know what you think the answer should be, right? But at the same time, it's also helpful to know that you need to be able to step out of that advocacy role enough to be able to say, well, how is it that the judge can give me what I want? You know, how can I best help them write that decision, as opposed to just, you know, pounding my chest and say, this is why I'm right.
I think you also learn not to avoid the hard questions, because those are the questions the judges are interested in usually. You know, the things that are pretty clear, the judges aren't going to necessarily ask about, but it's where it's a little bit harder. And there are different ways to do that. For example, you can say, well, you're right, Your Honor, for that little thing, maybe we do have an issue, but that is overshadowed by the preponderance of the evidence over here of how much better this my argument is versus my opposing counsel. So when I was on the panel and I would have somebody who refused to answer my questions, I almost just, I wanted to just close the case and leave, because if you're not going to answer my questions, why are you wasting my time? And why am I listening to you? If you really want to make a judge angry, don't answer their questions.
Yeah, that's something that I think is often lost on advocates is we're all very aware of how valuable our time is, but you don't appreciate the production pressures that all judges are under. I mean, they have dockets, they have pressures to get through those dockets. And yes, one of the worst things you can do to any judge is make them feel like you're wasting their time.
Looks like we may have had a buffering with Azie.
Well, so I'll dive into the next question, which was, what were the biggest surprises you encountered transferring from APJ to private practice? And for me, I would say one of the things that is very different about being in private practice is the opportunities and challenges that go along with working with larger teams of attorneys of various experience levels. And so, you know, we had the opportunity as judges to work as teams, obviously, because we always worked in panels of 3. And so, you know, I could have been on a panel with 2 of the 3 of my co-panelists here, but we're all experienced in patent law. We're all experienced in, you know, diving into the intricacies of cases and the intricacies of technology. And when you're in private practice, you know, and as a partner in private practice, is involved in training the next generation of lawyers. And just the getting used to that again and working through some of those processes again are something that I, you know, has been an adjustment coming back into private practice.
I'm sorry, I was like, I froze just now. I don't know what happened to my computer. I think there was one thing that Judge Kaiser, you mentioned about, like, you just shift the perspective. Can you share, like, how did you shift the perspective I mean, was it like a second nature to you?
For going from being a judge back into being a practitioner?
Private.
Yeah. No, I mean, I think you always have to sort of, work through the thought processes. And I'm sure others have had this before where, sometimes I represent in PTAB cases both petitioners and patent owners. And so you have to always remember which side of the V you're on. I think, when you first come back into private practice, you have to remind yourself sometimes that you're not the decision maker anymore. And sometimes it's no fun that you don't always get to be right anymore, of course, as Rick said, unless the Federal Circuit reverses you. But, you can have the best argument in the world, and it can be so frustrating if the board doesn't get it. And you're like, if I could just have them in a room and talk to them like I did when we were on a panel together, then they would understand. But you don't get to do that anymore. So yes and no on the second nature. I think it's always just remembering what your perspective is and remembering what your goals are and how you communicate them.
Thank you. So I'm just wondering, within when you're transitioning from one space to another, from the government to the private practice, I wonder if there is like a mentoring that is happening when you are in the private practice. I know that all of you are accomplished judges, but at the same time, maybe there is a mentoring that you can seek after in the private practice.
So I'll say from my perspective, and others can jump in, I think all law firms have different processes for integrating people of different levels in. So I've been pretty fortunate in having people in my law firms kind of, be invested in my integration and getting to know people and all of those things. So I think that definitely helps with the transition.
I know for me, I was in the patent office for over 25 years. And when I spoke as a judge, I had to be careful what I said and who I talked to. So for me, I needed mentors in business development because that's just not something I had ever done before. And luckily, I've gotten those mentors. It's still, for me, given my background, it's very hard to do. But private practice, if you find the right people, it can be very helpful to help you with those things that you're just not as comfortable with, that when you grow up in a law firm is just second nature.
Thank you, Judge Green. Anybody else want to chime in, or we can move to the next section, which is the PTAB insight and judicial wisdom. So this section will be led by Judge Ward. Judge Ward, you moved from PTAB to private practice. You were at Finnegan and now at Greenberg Traurig. And what valuable insights that you bring to the private law firms from your experience?
Judge Ward, you're on mute, I think.
Thank you.
There you go.
Yeah, so somebody's got to do it, right? Once every video conference, somebody has to talk on mute. Thanks, Azie, for the question. I'll say something that's been a consistent thread or theme for me in my work now back in private practice is taking part in the strategy decisions for a case. I've always enjoyed the strategy of patent litigation. It's one of the things that I was really looking forward to about getting back into private practice. And one aspect that I now bring, having had 5 years of experience as a PTAB judge, is really the capability to take a hard look at a list of arguments and identify those that aren't worthy of going forward on. I think one pitfall that many attorneys fall into is that they bring too many arguments. And at the end of the day, if you're bringing 7 or 8 or 9 arguments, you can't give equal emphasis and attention to all of those, at least not in an effective way. So time and time again, I find myself as the person in the room that's trying to take a high level look at the overall list of arguments and identify those that should hit the cutting room floor, giving us more time and ability to focus on what I think are the more persuasive of the arguments. I can tell you that from the judge's perspective, I appreciated that, right? I mean, it's difficult when you have a party come in front of you with just a laundry list of arguments and they're trying to cover them all and they want more time to try and cover them all. And many of them have no chance of carrying the day. I always appreciated it when an attorney, an advocate would come before me and say, I've got 3 arguments I want your honors to focus on, and really give full time and attention to those 3 arguments.
So Judge Ward, from your experience, what is the ideal number of arguments? You say like a long list of arguments. So what would be the ideal number of arguments that will win your heart?
You know, the answer to that is there is no ideal number. And I'll tell you that by telling a story about when I first started at the board. Judge Schaefer, a very senior PTAB judge, I know all of the folks on this call knew Judge Schaefer well. He's now retired from PTAB. But I remember asking him early on as a judge if there were certain cases or even templates that I should look to as being useful in helping to draft decisions. And Judge Schaefer said, never use a template. There is no template. This is the law. Every single case is unique and specific to the facts and the law that applies to those facts, and you should give that attention to every case. So similarly, I give that answer now when I'm working a case and somebody says, well, let me have a template. And I say, there is no template. This is a unique case and you've got to approach it uniquely. So 3 arguments may be the best for this particular case and 7 arguments may be best for the next case. You've just got to make that judgment call.
Yeah, the answer to any question like that is always going to be it depends, right? Like I was on a panel, I guess a week or so ago with some current PTAB judges, and you know, people will ask like, what's the best way to address this issue or that issue? And that I 100% agree with Trenton that you have to look at what is the best form of advocacy for your client. And if you're gonna like just throw everything up and see what sticks, you may lose sight of what your best argument is, and the board may not see it because they've got to dig through all these other things that, you know, are not that helpful.
I also want to provide a caveat, and this gets a little bit also back to some of the things we've talked about, former colleagues not always getting what you're trying to do. I'm currently on appeal defending a decision from the PTAB, and we basically had 2 sets of grounds, and the board said it really liked the first set, which was great. That's why we led with it. But this shows the wisdom of the Supreme Court SAS decision, because the second set depended on a claim construction, and they said, we don't like your claim construction, but they had to go on with it anyway. By the time we got to the end of the trial, they said, we love the second ground. We're not even going to reach the first ground. So you do not have to know how to lead with arguments, but it's also good to know when to stick with things. Importantly, we were talking about 2 arguments there. So it's not like we were burdening down the system with 20 arguments, but you know, the whole point of a trial is to try to convince people. So, you know, just give them the chance, and sometimes they'll see it.
I also think what was useful about being a judge is I sat on over 2,400 ex parte appeals, over 300 AIA trials. You see so many issues, and you can see things that a lot of other people can't because they just haven't seen that many cases come in front of them. So sometimes you can come with arguments that other people just aren't seeing because they just haven't seen as many things as you have seen.
By the same token, sometimes you're wondering, why aren't they arguing this? Why are they going? And the advantage of having been an advocate is sometimes you know, oh, the reason they're not arguing this is because they have another application pending where that'll be a problem, or this will hurt them in district court or something like that.
Yeah, and one of our audience members, Lisi, asked a question about, are there any clues in institution decisions to figure out the arguments that will resonate with the board? And to Rick's point earlier, I think that's a mistake that people often make, is assuming that preliminary things that the board says in an institution decision are the final answer. I had a case recently where I was on the patent owner side, and we had made an argument at institution. The board disagreed. We actually tried rehearing on institution. The board still disagreed. And that was the argument that won in the final written decision. So, it can be important not to assume on both sides that is the final answer.
Yeah, I would agree with that, Jessica, especially if the institution decision notes something along the lines of, petitioner's expert says X, and no rebuttal expert's been provided. That can be viewed as an open door to come in with that rebuttal expert testimony to give the board, the panel, a more complete picture.
Judge Ward, moving to a different questions, like any insights for attorneys in oral arguing before the PTAB?
Yeah, absolutely. And this is the question that we get a lot, not surprisingly, Azie, and I'm sure my former colleagues have some thoughts on it as well. One key piece of advice that I give advocates is, I think this is true for pretty much any tribunal, but I can guarantee you it's true if you're standing in front of 3 PTAB judges, and that is to treat every question as a gift, right? A question during the oral argument is a gift. You should treat it as so, because it's an indication that the judge, at least that one judge, perhaps the entire panel, but at least that one judge is undecided on the point that you're asking you about. So you've got a chance to move the ball, right? If they've made up their mind, they're not going to ask you a question about it. So if I'm the judge, I'm asking you a question, that's an opportunity for you to really dig in, try and understand the particular inquiry that I have. That's sort of first and foremost. Make sure you really understand what the judge is asking you, and then come in with a meaningful response to that. This kind of follows up on something that we talked about a little bit before, but Judge Torczon mentioned that don't let the judges think that you're wasting their time. That's what happens a lot when I ask a question. When I would ask a question as a PTAB judge, I'd get this look from counsel like, oh, wow, you're interrupting me and I'm not going to make it through all 342 of my slides, right? That's not what I want, right? I want you to be engaged. I want you to welcome and positively receive that I have studied the case and I have a particular question that I want you to help me solve. And I found that so many times that advocates weren't approaching it that way. And I think that there's nothing more rewarding than being asked a question and being able to answer it in a meaningful way that really maybe change the judge's perspective, or at least open them up to viewing in a way that perhaps they weren't prior to coming into the hearing.
Yeah, and sometimes the question, even if it's off the wall, I mean, it gives you an opportunity to make your point from a different perspective. So yes, it's a gift for the advocate too. I had a judge ask, in the very case I was talking about before, the judge asked an off-the-wall question about 101. Actually, a line of cases under eligible subject matter. This was an IPR. I mean, that's about as off the wall as you can get. But it actually really illustrated. All of a sudden, we had this really nice 1 minute, 2 minute discussion about why the claim construction that we were pushing for actually made sense, and the problems that would come out of looking at it a different way. So yes, definitely embrace the questions. I also think the slideshow or the slide presentation point is a good one. I was asked just the other day, what's important in putting together a slide presentation? And the answer is the slide presentation is supposed to support the argument, not the other way around. And
lots of nods on that, Rick. Totally. Yes.
Yes. So prepare your 300 slides if you absolutely must, but the key there is make it modular, right? So that you can jump around and hit points as they come up. So maybe you have 3 slides on point 16 that you never planned to get to, but all of a sudden Judge Ward's asking you questions and boom, you can jump to those slides. But if you wanted to do a forced march, you'll never get there. Judge Ward will never get the answer to his question. So use it as a tool, but don't lose sight of the advocacy, and don't lose sight of this is your opportunity to talk to the panel, not talk at them.
Yeah,
I'm sorry.
I was just going to say, sort of to that end, and I think all of us would say answer the question. You would be surprised how many times I asked a question in oral argument and the advocate said something like, I'm going to get to that in a minute. And first of all, you've just made that judge feel like, okay, this advocate does not think that my opinion is important. So even though I'm going to be the one deciding their case. But also it's back to Judge Ward's point. You haven't taken the chance to, give the judge your perspective. You've put off the thing that they were interested in. And then another point that I wanted to make was, like, advocates so often want to fill all the space that they're given. So you want to use every single word. You want to use every single minute. And to me, it's such a skill when people are willing to stop talking and sit down. I've seen people reserve 15 minutes for rebuttal, and they then just want to rehash everything that they've said. It can be so much more effective if you just say, here are my 3 points, and you make them, and then you sit down instead of talking and the judges have tuned you out. So my other point is that advocates should not be afraid to stop talking.
Well, Jessica, I agree. It looks like we've got a potential new panelist that's joining us, at least by chat window. Former Judge Trevor Jefferson has asked a question about misconceptions. And Judge Jefferson says, are there any misconceptions you've heard of or experienced in private practice about how PTAB judges reach their decisions in a DI or a final written decision? And thank you, Judge Jefferson, for that question. I'll say that one misconception that I constantly run across is that there's an assumption that some have that once a judge has authored a decision on an institution, that they're looking to sort of protect that decision in their final written decision, right? So they're looking for ways to confirm what they already found. And I'll say in my experience, that is absolutely not the case. At the end of the day, each and every PTAB judge that I worked with wanted to get it right. They wanted their decision to be correct on the merits and the law. And if that meant in some way upsetting or going against a determination that was made in the decision on institution, then so be it. So that's one misperception that I feel like I've encountered quite often coming back into private practice. And I don't know if Jessica, Rick, or Laura, if you guys have experienced anything similar.
One thing I would say is I have heard the misconception that that it's only a panel of 3 judges in name, and it's really just one judge deciding the case. And I think all of us would agree that that's affirmatively not true. For me, I was always very engaged, and I saw other judges always very engaged in, the deciding of a case. The reason, there's been so much made about the relatively small number of dissents and concurrences. In my experience, that is usually because the judges talk through the case and figure out where there's common ground and where there's not. And oftentimes there's a way to decide the case based on the common ground. But even just recently, I think we've seen coming out of the board on AIA cases more concurrences and dissents. So that's one that comes to mind for me.
I think sometimes, I'm sorry. I think sometimes you have to go back and look at your own arguments and see if you actually argued what you thought you argued. Because I think rather than blaming the judges, you should think about, did I present my case the best way I could, and take it as a learning experience. Because the judges do not have nearly as much time as you have looking through the case. And sometimes you're just presenting your argument in a way it's hard for the judge to understand when you're doing 3 or 4 different sitting on 3 or 4 different oral hearings in a week or 2 weeks. You really need to be clear and take that step back. And am I presenting myself clearly to the judges? I'm sorry, Rick.
That's fine. That's a great point. I was going to build on something that Judge Ward and Judge Kaiser had said earlier. Every case is unique. It's good to be able to see things from both a petitioner and a patent owner perspective. Have the same flexibility in looking toward panels. So, if you want to pull out the statistics when you're talking to the client because that's what they want to see and say, oh yeah, this panel, they're this likely to institute or not. That's fine. But just as if you always represent petitioners or always represent patent owners, there's a tendency to start drinking your own Kool-Aid. And as Judge Ward said, you have to look at every case uniquely. So yes, you can have your presuppositions about what a panel is going to do. And frankly, Trevor, I've heard every possible variation on what panels think and do that you can imagine. It's fun to have those, but when you actually go back to being an advocate, you really have to play it straight. Because among other things, if you're a good advocate, you're not just talking to this panel. You're also talking to the Court of Appeals, right? I mean, there are lots of different audiences. And if you get so fixated just on the panel and what you think their biases are, you're going to be missing out on a lot of stuff that's going on in the case.
Thank you, everyone. I think in the interest of time, we're going to move to the next section. So it will be in ethics. The session will be ethics. It will be led by Judge Torczon. So you spent about 20 years in the public service before joining your first U.S. law firm. So the question to you is, what are some ethical guidelines APJ must observe when they leave the PTAB as they enter private practice?
Okay, well, thank you for that. And that actually reminds me of an important ethical point for this presentation, and that is the standard disclaimer. So the views we've expressed here today are the views of the respective speakers alone, not our clients, not our current or former employers, not the sponsors of this program. And so take everything in that spirit. Because we're talking about the value of bringing APJs into your practice, and that's really good. It's also important because this is a legal sphere. There's always catches, right? And so one of the very first catches before the APJ even is hired is while they are still employed, they're not allowed to seek employment in a matter that they're working on, right? And that makes perfect sense. The last thing you would want is for one of your judges to be negotiating employment with the other side. So typically the way that happens is the judge either just walls off those potential employers, or they recuse themselves from the case. And those are both fine solutions. Couple things. One, it only works in one direction. So if you hate one of your judges, you can't try to get them to recuse by making them a job offer. It doesn't work that way. All you'll do is probably alienate yourself from the entire panel. The other thing is that the rules are a little bit looser for the clerks. They just have to disclose to the judge, because the judge can recuse the clerk without recusing, the judge. So that would be the big pre-employment consideration. Post-employment, there are a lot of considerations. So the first of all is the Office of Enrollment and Discipline, when you leave, will make you do a written undertaking that you're not going to work on cases that you worked on. And there's really no surprise there because it's actually criminal for you to do that. So that's a lifetime ban for everybody on anything they've touched. There's also a 2-year bar for working on anything that was under your responsibility. And this is particularly important for APJs who are in management roles, because even if they didn't touch the case, there could well be something that was under, their responsibility. And I think, again, the idea is that there might be some unfairness if, you were the boss of one of the judges on the panel, and now all of a sudden you're showing up and advocating in front of that person. So those are two things to keep in mind. Interestingly, the Department of Justice has said that not participating means not representing. So you can still participate behind the scenes. You can advise, counsel, do all of that stuff. You just cannot appear and represent. I think the additional caveat on that, though, is the disciplinary rules make clear that you cannot share confidences that you attained while you were at the PTAB. So, the better practice would be, if you touched a case, you really just cannot get involved in that particular proceeding at all. So the Office of Enrollment and Discipline has a somewhat confusing rule that seems to be in parallel with this, because there is a rule that allows you to get involved in cases that you have been involved in as an APJ with the written consent of the parties, which obviously makes no sense because the rule can't waive the criminal bar. But the important thing is the second part of the rule, because it extends to your entire firm, right? So this is something to take in, that firms would need to be aware of when taking somebody on. And that is, if they're still actively involved in a case that you were involved in, that could cause a problem for them unless they get written consent from all of the parties that it's okay for them to keep going, even if you're not participating in it. That is, so that is Rule 11.112A, and it's a very easy rule to overlook, and it's really important to pay attention to it. So those are some of the big concerns. There are also some other criminal bars, particularly about representing foreign entities and stuff. So people should be sure that they are paying attention to the guidance that they are getting from OED when they leave. I think probably one last thing that is worth noting is for marketing purposes, it's actually improper under the Office of Enrollment and Discipline's rules to state or imply that you have an ability to improperly influence an agency or official. So I think most APJs, I'd hope all APJs know better than to go there, but you might want to remind your partners. It's pretty easy to imagine a scenario where you're out on a pitch and a partner at your firm says, "Oh yes, our colleague here is a former judge and knows everybody on the panel." You need to soft pedal that stuff because it's technically a rule violation.
Any other takers from other panelists about ethics concerning this question about the ethical guidelines the APJ must observe when they leave PTAB? So it seems that APJs come with a lot of assets to the private practice, but at the same time bring a little bit of complications.
Yeah, I mean, if you think about it, that's always a concern, that there's a revolving door, and the answer is there are ways to manage it. There's always been this concern, and there's always been ways to manage it. You just, as lawyers, it's up to, and particularly on us as former APJs, we need to be sure that it is getting managed, because we don't want it to be a problem either for our firm or for ourselves.
But these are considerations for everybody in the office. I mean, when I left as a lead, as a primary examiner, I had a whole bunch of restrictions as well. So it's very common in government. I do think you have to be extra sensitive as an APJ, because especially now, since the board and APJs are so much in the spotlight. But I think Rick's overview was fantastic, because you do have to go someplace where you can't sign anything for at least a year. So they have to have the resources to be able to, they can't expect you to come on and start signing briefs and IPRs and things like that.
Yeah, Laura's point's a good one. I mean, when I used to be in the solicitor's office, which is where I was before I went to the board, we often would be involved not only in employee depositions, but even former examiner depositions, because ostensibly the examiner is just sort of an extension of the director. And so they have privileges that the director might not want to have waived. And in a couple cases, we ran into problems where former examiners were brought on as experts to talk about patent office proceedings and how they affected the case. But in fact, they had been involved in the case. And you could see how it make their testimony way more impressive for a jury. But at the same time, that's actually a criminal violation, right? Because they're sort of profiting off of things they actually did at the office. So it's not that a former APJ couldn't testify as an expert, but they better be sure that it's in a case that doesn't involve a patent or an application that they've touched, even if the one they touched is a parent application. So, you really have to do your due diligence if you're doing experting work.
But
yeah,
it can be very complicated. Oh, sorry.
No, I was just going to say, I mean, I think the way that I navigated a lot of these issues, and I suspect for Trenton too, because we were both litigators in prior lives, was I did a lot of litigation work, when I was under my bar period. And so, I couldn't appear in PTAB cases, but I could appear in district court cases. So I went around and took and defended a bunch of district court depositions. I argued a Markman hearing in Marshall, Texas, and did a lot of those things until I could actually appear in PTAB cases.
I was just going to say it's very hard. As an examiner, I was a primary when I left. You get about 20 hours per case. You've been there for quite a few years. That's a lot of cases. Like I said, I sat on over 2,000 ex parte appeals. I couldn't know if I sat on something or not. So I agree with Rick that you really do have to go and make sure you're doing your due diligence and checking things and making sure that you weren't on something that you didn't realize that you were on, because you just can't remember everything you worked on. So I could see how it could be done very inadvertently.
When you leave the office, they will give you sort of a list of things that you've touched. My experience is it doesn't match up very well with firm conflict systems. So you still kind of need to be careful. I think the other big take-home lesson, though, is like everything else in Washington, it's less the crime, it's more the cover-up. If you do find you've crossed the line, do everything you can to fix it. I had the experience where a former group director was acting as an expert in a case where he'd signed off on a restriction requirement back when I think he had been a supervisor. And he took the position that he'd done nothing wrong and didn't have to give back the fees or anything like that. And the Office of Enrollment and Discipline disciplined him, which wasn't the surprise. But then he pushed the issue into district court, and the district court judge was mad at the Office of Enrollment and Discipline for not being harsher to him. They thought he was being too nice. So, it's just, try your best to avoid the conflicts, but if they do come up, do your best to cure it. Don't, it's too important. And as I said, there are criminal statutes behind a lot of these things. You just don't want to mess with that.
Thank you for all the thoughts, and we're going to go to the last section, which is a collaboration between current and former world, be led by Judge Green and Judge Green. So the question is, how can you preserve respectful interactions with your former APJ colleagues while advocating for your clients?
I loved being at the PTAB. I loved my colleagues. I'm still friends with a lot of them. And it's like everything else. You just have to be careful what you talk about. You never talk about specific cases that you're on. You can talk in generalities, but a lot of times that we talk about each other's kids and other things. So it's just being respectful. And it can be the same thing leaving a firm, because when you leave a firm, if you have confidential information about a client and you can't go back and talk to your firm about those clients, you can't talk to other clients about those clients. So it's really not all that much different. It's just remembering that your role is different and you can't have the same conversations that you used to have. And I would never want to put somebody who I consider a friend in a position where they're thinking that I'm trying to get something out of them that I shouldn't know.
Yeah, I think one of the most interesting interactions I think I've had with former colleagues is when you're speaking on panels, because I think sometimes it reminds you of things that you forget about the inside and some of the considerations that they have. And then I think it allows you to share a little bit about your perspective of things that matter to the stakeholders on the outside. And I agree 100% with what Lora said. Those interactions are always respectful and you're not trying to necessarily get anything out of them, but it is a good opportunity for respectful collaboration on both sides of the moat, if you will.
One of the funny things about living inside the Beltway is this is not an abstract problem. I mean, when I say that current APJs are my neighbors, one lives 3 doors away. So for me, the good rule of thumb is, how am I interacting with this person? What role are they playing currently? So obviously, if I'm at an oral argument, they're the judge, right? Even at a conference, they're a judge, right? They're there because they're a judge. If I run into somebody in a grocery store and I'm already on a first name basis with them, then I'm going to call them by their first name. If I'm not, I might call them judge though. So, it really depends, but, the human mind's got that ability, right? To be context sensitive, and that's really all it takes. And in fact, with, professional organizations, a lot of times you'll find yourself collaborating with judges in non-case contexts. And, there's nothing wrong with that. And in fact, that's great. The board likes the bar to be there and understand what their issues are. And we, of course, like to understand their issues.
Judge Ward, do you have any thoughts about preserving respectful interactions with your former APJ colleagues?
No, just really to kind of echo what my fellow panelists have said. I completely agree with Judge Green that I love my time at the PTAB, and primarily because it's just such a really incredible group of individuals, many of whom I'm still friends with. And, I think each of us on this particular panel here today sees ourselves as somewhat of ambassadors for the PTAB. I know that I think very fondly of it, and I hope the PTAB continues to be looked at as a high bar adjudicatory tribunal as it's developed itself. And so I view myself as an individual to help in keeping that perspective and view upon the PTAB and the adjudication that happens at the PTAB. But Judge Torczon talked about non-judge interactions, collaborative interactions with non-judges, and no one knows that better than Judge Kaiser, as she's married to a current APJ. So she does a lot of collaborative activities that don't involve adjudicating with a current APJ.
I'm not really sure how to respond to that, but yes, we do not talk about cases, but I am, we were the only, I think, married APJs at the time. We were both at the office, and he remains in the government and I'm in private practice. For the official record, he recuses himself from all cases involving me or my law firm. So there you go.
Yeah, I have practice on this all the time because my wife works as a lawyer for a government agency. And the funny thing is we never talk about specific cases, but she feels free to ask me my thoughts on the Freedom of Information Act. So,
Sounds appropriate, Rick.
I think we are at the end of the time, about 2:15 Eastern time. And I would like to thank you very much to our wonderful panelists today for sharing their insights and experiences. I would like to thank the VPG team, especially Caitlin, Michelle, and Nicole for their hard work to help put this together. And I would like to thank the audience who spent their time and participation today. And because we don't really have time to take any questions today, I encourage you to continue this discussion outside of this panel. If you have any questions, and you can just contact the former APJs on this panel directly. And you may find that information on the website. Thank you, everybody.